You can't act in any way that's contrary to your client, and that also brings in the question of conflicts. You may be going in for just one day for that client, but if you have represented the opposing party on a related matter or another matter in the recent past, that's still a conflict in limited representation. You still have that duty of loyalty. You ought to be screening for conflicts in the same way that you would in full representation. Finally, the ethical requirement of confidentiality. You cannot breach a client's confidences, and that includes not just attorney-client communications, but other things that are told to you in confidence which, if shared with other people, might be negative or embarrassing to your client. That, I think, is pretty clear to most of us. We understand those concepts. They're not different in limited representation. The one thing that is different in limited representation is this concept that Judge Winnick mentioned that's in the SJC rule of informed consent. And that is written into the SJC rule. That is something which becomes more important, both from an ethical point of view and from a malpractice or potential malpractice point of view, is to make sure that in a limited representation context, your client knows what he or she is getting into and is making an informed decision about that. You've got a set of materials in front of you, which now we've been using for 3 years, and they keep getting better all the time. They are terrific materials. And for example, in the appendices, you've got a number of very helpful materials. Appendix 1 is a client handout. A lot of these appendices go to this question of informed consent. So the client handout that's in Appendix 1 will inform the client of what is limited representation. What is going to be your obligation? What is the lawyer's obligation? And how are we going to divide up these tasks? In fact, limited representation has ended up in less complaints, fewer complaints to the Board of Bar Overseers and fewer complaints on malpractice than general unlimited representation. The reason is because the client and the lawyer are negotiating each step of the process. They need to be discussing things. In the old days when you had an unlimited representation, general appearance, you sent a bill to the client for the work you did last month, and it turns out to be, $8,000, all according to the hourly rate that you had quoted them. They know the work you did, and they're shocked. I didn't expect a bill for $8,000, and the tension between lawyer and client starts developing, and those are often the cases that end up in either claims of malpractice or things that get reported to the Board of Bar Overseers. In limited representation, you can only have that disagreement, hopefully, about one day and one event. You're a lot closer in time to discussing any unhappiness your client might have. But do pay great attention to the informed consent. That client handout at Appendix 1 is designed in a way where you can give it to your client when they come in for that first day. And it goes a long ways towards satisfying the question of informed consent. One of the things that Judge Winnick mentioned was the limited representation has to be reasonable. While that may seem a fairly easy concept, the fact is some things are not reasonable. They can't be separated out, or it's not something that can be handled on a limited representation basis. So if the client comes into you and says, I want you to help me in a limited representation way in connection with my divorce, I want you to handle the alimony and support issues, and I will handle all the issues having to do with valuation and separation of my pension plan. Not a good idea. That's exactly the kind of thing that the client's going to end up having a big problem with, perhaps not understanding that the pension plan can be a big part of the process, and you really can't do the alimony and the support parts of it without and the property division without talking about the pension plan. So there's that question. Is it an issue or an event that can be separated? Second, you've got to understand whether or not the client really understands what the separation is and who's going to be doing what. It's very important. You might end up in a situation where somebody comes into your office and wants to do limited representation, and they have some kind of learning disability, language disability, that prevents them from effectively representing themselves and from understanding what the limited representation role will be. Don't get involved with something if it's not reasonable to divide the issues and divide the tasks. Judge Winnick mentioned that you can define it by the day, so that, for example, you can file an appearance for a particular day. You can also define it so that you go in for that one day, work out a fee agreement with your client, you pay me $300, I'll represent you at the motion hearing on February 18th. You can also define it by a stage. I will represent you through temporary orders in a divorce case. Set the amount and do the work and be done with it. Theoretically, you could also divide it by task, as I've talked about, or issue. Alimony versus child custody. There weren't very many people in the process that thought that would be doable, to go in with your client on motion day, have motions that had to do with both custody and support, and somehow the lawyer does one part and the client does the other on the same day. And that's really not been the practice. People have not been doing that. It's been by the day or by the stage. By the way, in the probate and family court in particular, and Judge Winnick can address it more in the housing court, there's a specific notice of limited representation. And again, you have that attached to the materials you have. And that is a document which, if you're going to do the limited representation, you need to be very familiar with. It's on page 87 of the materials.
Actually, it's not.
Was that?
It's not going to show up on the same page numbers.
Oh, it's not?
It's 80, it's 90.
Okay, I'm sorry. Apparently what was sent to me over the internet, by email, was not completely page consistent with what you've got, but you've got the notice of limited appearance at the end of the materials. Joanna tells me it's at page 90.
90.
Page 90, so close. But look at that notice. You need to be specific about that notice, know what you're doing. You need to file that notice. If you go into the probate court and you file a memorandum on the issue of temporary support or temporary orders, and you have not filed this notice of limited appearance, you have filed a general appearance. If you don't file this form, you are in. As soon as you file a pleading, you're in for all purposes, and you can't get out without the court's permission. This was a huge issue, because in the old days, if I went into Judge Winnick's courtroom and I filed a motion with my name on it, and then I had a disagreement with my client the next week, or my client couldn't pay me anymore, my client didn't want me involved in the case, I had to go in and ask Judge Winnick's permission to get out of the case, and Judge Winnick would look over the bench and say, no, I like having lawyers in this case. Whether you get paid is your own problem. Things go
Depends
up.
on the lawyer.
I'm not going to let you out. And it's the bane of a lawyer's existence, to be stuck with the case from hell. You've got a disagreeable client, they don't like what you're doing, you don't agree with the positions they want you to be taking, they're not paying you, and you can't get out because there's a trial scheduled. It's involuntary servitude. And with the limited representation, you don't end up with that problem if you do it right, okay? But if you look at that form and fill it out and say that you're going to be in court on February 18 for the motion session, you file your notice of appearance, file whatever motions are on for that day or oppositions, you go into court, you do your representation, you don't need to ask the judge's permission to get out. You've already filed the notice of limited representation, and my recommendation would be, don't even bring the issue up. After the hearing, You go outside, confirm with your client that you're done. You take the next form that appears in the materials, which is the notice of withdrawal. You fill it out, you go down to the clerk's office and file it before you leave the courthouse. And then serve copies on the other side. You're in, you're out, it's surgical, there's no ambiguity about it. Nobody the next week is going to wonder whether they have to serve you with copies of the pleadings. No lawyer on the other side is going to be calling you to try to negotiate the case. Nobody's going to be expecting you to appear the next time there's a motion hearing or complaining to the Board of Bar Overseers or anybody else that you didn't show up. It needs to be clean and neat. Now, that is very important. It's very important for your client to know that if you want to do this effectively. You can file a new one. If after the hearing, you go down and file your notice of withdrawal, the client says, "You did a great job. Now I realize that it would have been crazy for me to come into court and try to do this by myself." You say, "Fine, we've got another court hearing coming up in 2 weeks. I'll file another notice of limited appearance." You also want to have a separate written engagement letter, a fee agreement with the client. And we have a number of proposed model fee agreements specifically related to limited representation, which appear at Appendix 6. Those fee agreements are very different from the usual fee agreements that you might get. And it's very important, it's essential that you use a written fee agreement so the client knows, and you know, what it is you've been obligated to do. Because the biggest problem with this area of practice is a misunderstanding of what the client is expecting you to do and what you have agreed to do. So make sure you look at those. In the materials, there's also, at Appendix 4, a sample intake form. So that leads you through the process of informing the client as to what the limited scope of representation is, and so that they know. So that if you're saying, well, look, I'll handle preparation of and drafting of the written discovery, but I'm not doing the responses for you from the other side to their discovery requests. Well, you know, the client has no idea what discovery is. And I don't want to spend, you know, an hour trying to educate the client. You do need to make sure they understand the materials here, and the intake form, things like that, raise these issues and make it clear that you've got informed consent, that you've gone over these issues with the client. This is just good practice, particularly as you first start out in this area of limited representation. I do want to emphasize something Joanna said, which is this is great for pro bono work. This is great, the limited representation, for the work you do for VLP. Used to be that when you tried to get lawyers to do pro bono work, you'd say, gee, I have a client that really needs representation in the divorce case. They'd say, is this going to take 10 hours or 150 hours? And you couldn't tell them because they were filing a general appearance and they couldn't necessarily get out. So lawyers were hesitant to make that kind of commitment. With the limited representation, they can do that, know that they can go to court on a particular day, do their work, get done, and leave, and then make a decision about the next hearing. But that is not what this is about. It is partly what it's about. We want lawyers to be doing this and making money. There is no reason that a client who can afford to have a lawyer representing them should be in court representing themselves, doing a terrible job, getting a bad result, when they could have, for $500 or $750, have had a lawyer in there representing them that day, rather than having to pay a $25,000 retainer check, which they're unwilling to do. And the idea is that once the client sees what the lawyer does, they'll understand what the lawyer does and agree to retain them for the next stage, and perhaps eventually for a general appearance. But it's meant to be an effective, useful, profitable part of your practice. So I've mentioned the client handout. I've mentioned the sample intake form in Appendix 4. You can also look, if you're wondering more about how the process works and how it's recommended to work, Appendix 3 has some flow charts so that you can be constantly touching base with the client, making sure that you're doing what needs to be done with respect to your limited representation. Another very important part of this process you should remember is the closing letter, the closing letter, a sample of which appears in Appendix 10 in your materials. A lot of lawyers feel it's very important to have a closing letter when your representation ends anyway. It's just good practice. It's defensive practice. It lets the client know exactly where they are. So a lot of lawyers send these closing letters anyway. You hired me to do X. I've done X. You've paid me. And I hope all goes well for you. If you want to hire me for something in the future, feel free to call. But in the connection with the limited representation, it's very important to make sure you close that loop and make sure that the client knows that it's over, and if there's any problem, speak up. Because you want to deal with it right then and there and to be very clear about it. The materials also include at Appendix 8 a follow-up checklist afterwards to make sure that you've done everything that you say you're going to do and to make sure there's a full understanding with the client about it. So I think I've handled most of the mechanics of the process in the probate and family court. Just to go over it briefly, you've got your first meeting with the client. Make sure you get informed consent. There are the handouts here. Make sure you're clear on who's going to do what. There's a form in the materials at Appendix 5 so that you can check off which tasks are going to be apportioned to the client, which to the lawyer. If you agree to do the work, you have a fee agreement that's specific about it. You have the notice of appearance that you file with the court. You have the notice of withdrawal, which you file with the court on your way out. You then have your closing letter and follow-up checklist, and you should be in good shape and ready to go. One temptation. You're in the courtroom, and you're making an argument about child support, and you've agreed to represent the client on child support. Your fee agreement and notice of appearance say, I will represent you on child support at the hearing in the Middlesex Probate and Family Court on February 18th. You get into court, and the judge says, well, that's fine, but doesn't the child support depend in part on the visitation schedule? If the child is going to be living, Monday through Friday with the mother and every other weekend with the father, then we're going to order, a substantial support because the mother is going to be paying most of the expenses. If it's really going to be 50-50, that's a different situation. So I really don't think I can answer the question of support without going into visitation. Counsel, you're willing to address the question of visitation, aren't you? Big mistake to go along with that or to allow that to become ambiguous. At that point, the thing to do is to say, Your Honor, I have filed a very specific notice of limited appearance. That's not something I've agreed with my client that I will do. If you feel strongly that that's the way we should handle it, we're going to need to be called again a little bit later, and I'm going to need to talk to my client outside. Be very careful about changing the scope of your representation because it can be a real slippery slope. You've done a great job in your office. You've done the intake. You've done the client handout. You've done everything right. And you've got your fee agreement that's specific. You get to the courthouse and all of a sudden you don't have all these forms and you just say, oh, what the heck, we're here anyway. Sure, I'll make the argument on visitation as well. It's just a mistake. You're better off either coming back another day, going back to the office, revising the fee agreement, and adding this other matter, and doing a change of scope agreement. And the change of scope agreement is also included in the materials that you have. You know, I didn't make a note of which appendix that was, but I will a little bit later. Do you have it there?
Appendix
Okay.
7.
Yeah, Appendix 7, and that's at page 72 in your materials. We were lucky to be able to piggyback on what happened in these other states where they did the limited representation before we did, so that we didn't have to reinvent the wheel. And all of the other states said this change of scope issue is a very significant issue. Be careful about changing scope of your representation on the fly, because all of us went to school to help people. And your first temptation is to say, yes, I'm here anyway, I like you, we get along, I believe in your case, I think you're right, sure, I'll represent you on this other issue. Resist the temptation. It's what we've been told by everybody. So that's a very important part of it. Interestingly, Judge Ginsburg, Edward Ginsburg, is a retired probate and family court judge, was one of the biggest opponents to limited representation. And for years, he was our biggest hurdle. He'd show up at every meeting we had and say how terrible it was and how he wanted lawyers that were going to take responsibility for their cases from beginning to end. And subsequently became one of the biggest advocates for limited representation. And he and I are driving down to Connecticut a little later in the month because they're having all the same problems down there. And their bar is skeptical, the judges are skeptical. And we're going to do for Connecticut, hopefully, what Maine did for us, which is go down and describe to them how the process works, what they do need to be concerned about, what works fine. And hopefully they'll come up with the same kind of a process that we have, and hopefully it'll work well for them. I've gone through what I wanted to cover, and we'll have a period for questions at the end. And at this point, Judge Winnick is going to talk a little bit about the practicalities of how this has worked in the housing court and some of the things that he sees in the housing court that you would need to know in connection with doing this work. Judge Winnick?
With a show of hands, how many people here are primarily going to be practicing in the probate court or the land court? And how many people are going to be practicing in the housing court? All right. There are two models that you heard today. One is a model where the representation, the limited representation, is negotiated and decided upon in your office. Someone comes in and you have a consultation and you agree upon the limit of the representation and the fee. That would typically be what takes place, I would think, in the probate court or in the land court. It's not going to happen on the day of the hearing in the hallway. And everything that I've heard makes perfect sense for that model and what you need to be careful about. So what I'm going to say is going to be based on my own predilections. I'm not speaking for the trial court, nor am I professing to state trial court policy. I think as a practical matter, it is beneficial that you tell the judge that you are appearing on a limited basis and what the scope of your limited appearance is. The reason for that is the judge is likely then to tailor what it is the judge is going to do that day to your appearance and will not start to step outside of it and try to get you to do something that you haven't undertaken. I don't believe that the judges see this as a game of gotcha, where the idea is to try to rope you in to full representation. That is not what we want to happen, at least not what I want to happen. I want you to be successful within the scope of the representation that you've agreed upon. You make it easier for me if I know it at the beginning. But there can be differing views on that. In the housing court, and I'll keep this brief because not many of you are going to be housing court practitioners, almost all of the limited appearance representation, the negotiation and the execution of the appearances take place on the day of the hearing. On a typical Thursday in the Housing Court, which is our summary process day in Boston, I'll have anywhere from 160 to 200 cases on my docket. I have Joanna's Lawyer for a Day program with a whole coterie of private lawyers volunteering the time. I have some of the law school clinical programs working in my court, and they are all at various points talking to the unrepresented litigants and then entering appearances, limited appearances, for a discrete task. Typically in my court, you would get a lawyer representing them on a motion to vacate default judgment, a motion to dismiss, a motion for execution, a motion, ironically, a motion to continue. You make a limited appearance to argue that the litigant should be given more time. Preliminary injunctions or temporary restraining orders. Motions to reconsider. Interestingly, a litigant the week before lost a motion, a motion to issue execution. The tenant loses. I'm not sure why the tenant's back in court, but they are, and this time they have a limited appearance representation lawyer filing a motion for reconsideration. Why? Because the unrepresented litigant couldn't articulate satisfactorily, in any satisfactory manner, the defense or the opposition that they had. Sometimes the judge will listen to it, sometimes the judge won't. And sometimes I've had limited appearance representations for a trial, but limited to the trial that was taking place that day, though sometimes I would grant a continuance. If I actually got a lawyer to enter an appearance for a trial, I'd then give the lawyer some time to prepare for it. But those are all on the fly. Lawyers who are going to have approximately 5 minutes, 10 minutes to prepare, unless they ask me for more time now that they have an appearance. And it's different than the type of limited appearance representation that would be conducted typically in the probate court, or I would suspect in the land court. But a few things nonetheless. It is important to consider and remember the back end, the withdrawal. Make sure the document is filed, the closing letter. One of the things that's likely to happen is your client's going to bring you documents and things to enable you to prepare for the discrete event that you're going to represent them on. You do it, you got to make sure that you get those documents back to your client if you are not going to be continuing the representation, rather than just waiting for the client to ask you for them. Why? Because the next time that client comes into court, if the client